Ito ang ating balita. Senador Drilon at Senador Ping Lacson sinupalpal ni Senador Tolentino. Panoorin ang buong detalye.
Preference of Senator Lacson, I would like to direct my questions to the interpellator, the minority leader, Mr. President.
I don't think that's proper, Mr. President.
Just for clarificatory purposes.
Just to clarify.
Just to clarify and for the information of this body, and it has been done.
I am not.
Well, perhaps the best way for the
Mr.
gentleman
President.
from Cavite is to make a manifestation.
Yes.
You know, the
Just a point of clarification,
the
Mr. President.
interpellator is
Yes.
Senator Drilon.
Yes, Mr. President.
You want
That
to ask
is-
a question? Ask
Yes,
the sponsor.
Of course, that's with the, if the good interpellator would like to clarify, Mr. President. Because this is germane to the issue previously discussed as regards the sovereign agent, Mr. President, which I think is very critical in Section 4 and Section 6, Mr. President. Or if the good
Mr.
sponsor
President,
can answer, I will
For
direct
an
this.
orderly proceeding, maybe the principal sponsor
Can
during the period of interpellation can
Yes.
attempt to answer, and we would react to that as an interpellator. But it's a little difficult to accept the process wherein the interpellator would be asked questions, Mr. President.
Mr. President, just for the information
Yes.
of the body and the general public, I just wish the body to be clarified regarding an item, which, of course, with the permission of the minority leader, regarding an item relative to Section 4 and Section
Go ahead,
6,
go
which
ahead,
we have
sir.
skipped.
Yes.
And if the good sponsor will answer, with more reason that I will pursue this, with the permission of the gentleman, of course. The discussion anchored on an agent acting in behalf of a state. Mr. President, if the two gentlemen would probably clarify to this representation, if an agent or a military officer or a police officer is acting pursuant to his duties, isn't it included in the state immunity doctrine? Considering that he is an agent of the state, he cannot be sued, Mr. President. Even if an act is considered as a terroristic act, he is not bound to be held in a foreign court or in a national court because he is acting in behalf of the state. Is my proposition correct from the two gentlemen?
The sponsor may react or answer.
As I responded to the distinguished minority leader earlier, the law does not exempt anyone. But the person committing the act of terrorism must be bound by the purpose as stated under the measure, Mr. President. If the purpose is different from or outside of the mission or the mandate assigned to that particular military officer or agent of the government, then he should be likewise held accountable or criminally liable for such act of terrorism, Mr. President.
Mr. President, with the permission of the
Yes,
good
Mr.
sponsor, in my humble view, this bill and the law should not apply to state agents because they are governed by some other law, the penal code or the or some other act. In fact, in the United States, Mr. President, the terrorism bill, as defined in Title 22, Chapter 38, U.S. Code number 2656, specifically excludes acts committed by includes only acts committed by non-state actors. So that a state actor, although he is liable for the crime committed, the crime is not under the anti-terror bill or law, but under another statute.
You
like
may
the
be
revised
referring
penal
to
code.
the Articles of War, Mr. President. If you are a member of the Armed Forces of the Philippines, then you are covered by the Articles of War instead of some criminal acts covered by the civil courts. You may be referring to that, Mr. President.
Yes. Well, because also...
But what about members of the PNP or some military or uniformed services that are not covered by the Articles of War? Does it also mean that...
Well, that is maybe the gentleman
Mr.
from Cavite.
President, perhaps the example cited by the good minority leader refers to perhaps the overall umbrella covering consular officers, diplomatic officers, which are probably exempt from suit. But there are peculiarities wherein and the good sponsor is familiar with this. There are peculiarities when our PNP officer is even made a police attaché. And as a police attaché, he has a diplomatic immunity likewise. So I'm referring, Mr. President, to a person who probably might be involved in espionage, who will later on claim that he is not part of this because he is a diplomat, and because of that, he is immune from suit, Mr. President, and therefore cannot be subjected to the provisions of this proposed bill, Mr. President. Just, I would like to clarify that, Mr. President. Or should it be expressly be stated in the proposed bill?
Mr. President, if I recall, in the last, in the previous session when this bill was calendared, I specifically asked the question of the good sponsor. It was a question asked in jest, but very applicable to what we are debating today. And I asked a specific question. Was Senator Honasan a terrorist? Remember, he was a member of the armed forces at the time that the coup d'etat was launched. And he did acts which will compel the government to do something. Now, in other words, by ordinary definition, because the law says any person, Senator Honasan would have been covered. But the gentleman from Cavite, the good sponsor, said, no, Senator Honasan would have been covered by the ordinary, by the revised penal code, including the coup d'etat, if it was existing at that time, but not by the anti-terror law because he was a state actor. He was a member of the armed forces. That's how the debate went on. Of course, it's a matter for this body to decide later on how to precisely define this. I am just basing my questions and interpretation on the phrase any person. That means whether or not you're a state agent, a law enforcement officer, if you commit acts which fall under the definition, you can be prosecuted under the anti-terror law. That's how I understood it, Mr. President.
Did the answer of the gentleman from Cavite, Senator Lacson, did the minority leader concur with the answer, with that answer?
I don't think so, Mr. President.
No. Well, Mr. President, under the present wording of the bill, Senator Honasan would have been prosecuted if this was law, because the law says any person. And,
except that there's no retroactive effect, Mr. President.
No, I mean,
at that time, hypothetical.
Assuming that at the time they were committed, this was already in existence. By the phrase any person, Mr. President, that would include Senator Honasan. Because it does not exempt state agents, meaning public officers, who could be prosecuted for another crime, but not under the anti-terror bill. That's all I'm saying. It's not that you are exempting from criminal prosecution the acts committed, but the prosecution should be under another statute, not under this statute. That's all we're saying. But of course, it's a policy issue. Right now, the good sponsor is saying any person is covered. And at a certain point, the chamber would have to vote on such policy issue, Mr. President.
All right.
Mr. President, one last point before I yield the floor.
Yes.
Relative to Section 4, which I recall was exhaustively discussed during that December session. I forgot the date, and it has something to do with the unlawful acts committed in or outside of the Philippines, Mr. President.
Yes, we will come into that later.
Just one last question, Mr. President, before I yield the floor. This is something to do with the long arm statute and the possibility of this jurisdiction serving summons or placing into its jurisdiction persons outside the territory of the Philippines, Mr. President. I did my research during the Christmas break, and for the information of this body, it appears, and perhaps the Committee on Foreign Relations should take cognizance of this, that the Philippines is not even a signatory to a very important convention, not related to criminal law, but civil or commercial matters, and it is entitled the Hague Convention on Service Abroad of Judicial and Extrajudicial Documents, Mr. President. What I'm trying to say, Mr. President, is how do we acquire jurisdiction of a person outside of the Philippines who apparently is planning to commit or attempting to commit any terroristic act if we cannot even serve the necessary processes or documents to acquire jurisdiction over that person, Mr. President. And to highlight the matter, Mr. President, we are very familiar with the Gon case, which involves a Brazilian president of Nissan who was prosecuted in Japan, went to Turkey, and then finally settled in Lebanon. And even Japan, with the help of the Interpol, cannot acquire jurisdiction over Mr. Gon, who apparently posted bail in Tokyo and then escaped before Christmas, Mr. President. So I'm looking at the administrative difficulty of enforcing Section 4 insofar as acts committed outside of the Philippines, Mr. President. That's my last question, and if the good sponsor or if the minority leader can help clarify this predicament on how our courts will acquire a long-arm jurisdiction over a person outside the Philippines, is for us to really analyze, Mr. President.
Well, the answer to that is yes, yes and no. No, if it's outside of the jurisdiction of the country, the Philippines, then we cannot acquire jurisdiction. But once he steps into our territory, then we can acquire jurisdiction under the proposed provision in this measure, Mr. President. And as we also mentioned last December, we are applying the territoriality principle. And you yourself clarified that when you interjected, that we can actually acquire jurisdiction over foreign terrorists, but only when they step on the shores of the country, Mr. President.
One last point, Mr. President. In terms of the prescription of crimes committed here, because we might reach a point, Mr. President, that the perpetrators might be in the Philippines, the other conspirators might be outside of the Philippines, and the period of prescription for those outside of the Philippines will start only once we acquire jurisdiction, once the courts acquires jurisdiction. So we might be placed in an administrative dilemma wherein some of the co-conspirators are already in jail, and then or perhaps released, or perhaps the crime was prescribed. But for the other participants coming from outside of our territory, it will only commence once they enter our territory, Mr. President. Am I correct? So this would entail a very difficult administrative, judicial, prosecutorial proceedings insofar as our criminal justice system is concerned, Mr. President.
I think the law on prescription will apply. For capital offenses, it's 20 years. So if that terrorist does not come to our country to be prosecuted, then, and after a lapse of 20 years, then the crime against him shall be prescribed. I hope I'm correct with my response, Mr. President.
Thank you, Mr. President. Thank you for the two gentlemen for allowing me to interject. I just have some administrative nuances that probably I will expound during the period of amendments, especially as regards the jurisdiction on criminal cases and the long-arm jurisdiction of our courts, if there is any, Mr. President. I'd like to thank the two gentlemen.
At siyan ang ating balita. Maraming salamat sa iyong pagsubaybay. Ito ang Balitang Express.